This is the true story behind the Netflix documentary, The Crash, and Mackenzie Shirilla. Hi, I'm Hot Scratcher. I'm a medical advocate for EDS patients. Mackenzie Shirilla has POTS, and that's what really first interested me in this case and why I had to take a deeper look. There is irrefutable biological and scientific data around this case showing that she was certainly unconscious when she hit the wall. So this case really hit home for me. We're from that same region, so I really understand how hostile the cops are there, how hostile the prosecutors are there. Now let's get into this case. So here's a quick recap if you're not familiar with the Mackenzie Shirilla case. On July 31st, 2022, 17-year-old Mackenzie Shirilla drove her 2018 Toyota Camry into a brick building in an industrial park in Strongville, Ohio, at 100 miles per hour. The crash instantly killed her boyfriend, Dominic Russo, who was 20, and their friend, Davian Flanagan, who was 19. Mackenzie survived with a lacerated liver, broken femur, and 3 broken ribs. The state of Ohio picked up the case, and the prosecutor insisted it was a homicide and that she executed a calculated murder-suicide and consciously and willfully drove her car into the wall, killing these 2 young men in an attempt to kill herself. The prosecution used the event data recorder inside the car. It's basically the black box of the car, along with text messages and accounts from their friends to basically show that there was a toxic relationship, and they really painted her with the mean girl trope and the crazy girlfriend trope, without a doubt. Mackenzie's lawyer, the defense, they waived the jury trial, and they also failed to provide an in-person medical expert to testify during the trial. Both of these were massive failures and mistakes in her defense. They were likely decisions made due to financial barriers, along with the assumption that I'm sure their defense lawyer told them that they had the case won, because it would have been absurd for them to have lost this case. But unfortunately, that is what happened. They ultimately lost the trial. After they lost the trial, Mackenzie's mom hired a really expensive defense team who again let her down a second time, as we'll get into in this video. On August 21st, 2023, Judge Nancy Margaret Russo sentenced Mackenzie Shirilla to 15 years to life in prison. Despite the confidence of the prosecution and the ultimate guilty verdict, the events on the night of the crash don't add up, not even close, as we will discover in this video. So what happened on the night of the crash actually? What were the events that led up to the actual crash? So Mackenzie, her boyfriend, and their friend were all hanging out late on a Sunday night until 5:30 a.m., at which point Mackenzie was going to drive them home. They were just hanging out, smoking weed, watching nature documentaries. Mackenzie herself was not smoking. There was nothing out of the ordinary. Their friend that they were hanging out with that night said there was no tension, no arguments. It was just like any other night. They even had plans the next day. When you're hanging out at a friend's house like that in the Midwest, you don't have access to food and drinks or anything. Nothing's open late, and it's dangerous to drive around at night because the cops are so aggressive. It wouldn't be surprising if Mackenzie didn't have enough electrolytes or fluids or food that night. They left at 5:30 a.m. and only 5 minutes later, that's when the crash occurred. Right where there was a bend in the road, the car kind of just kept going straight, blasted through a sign, and then smashed into a wall. The black box they recovered from the car, it only shows the last 5 seconds before the crash. And this is what it showed. The accelerator was at 100% with zero braking. There was a 142-degree yank of the steering wheel right before the crash. And then there was a switching of the gear shift from the drive to neutral position, from neutral back to drive right before the crash. So the prosecutor used that data to paint a picture of malicious intent. But ironically, that EDR data all on its own disproves that. In vehicular suicides, crash data always shows a stutter in the telematics. So even if a driver willfully drives himself into the wall, as the literature shows, when people are doing intentional crashes, their primal survival instinct always causes a micro reaction right before the impact. So one of these 3 things will always happen in these intentional suicide crashes. The driver will instinctively lift their foot off the gas pedal for a fraction of a second. They'll tap the brakes right before the crash, or they brace their arms against the steering wheel, causing erratic steering data. None of this occurred in Mackenzie Shirilla's crash. In fact, the data shows all by itself that likely the driver was unconscious while the passengers attempted to maneuver the vehicle to save them. This is all supported heavily and well documented in medical literature. Here is some of the literature that you can review. This is all on this Substack post. Visible Illness is a medical literature channel. We take complex medical literature and make it easy to understand for patients and their loved ones so that they're armed with the tools they need to advocate for themselves to get the care that they deserve. This case includes a lot of medical literature and even the world-renowned POTS expert, Dr. Kamal Chemali, differentiating syncope from convulsive seizures via post-ictal serum lactate and blood gas biomarkers, Journal of Neurology, Neurosurgery and Psychiatry, 2015. This is a really important one because Mackenzie had low blood oxygen and high blood lactate levels, which is exactly how you identify if a patient was unconscious or not during a crash. So those are irrefutable biological markers that really prove she was unconscious when they hit the wall. Suicide by motor vehicle crash, Journal of Forensic Sciences. This is the journal that shows how when you commit suicide by motor vehicle, there is always a stutter. You always tap the brakes or guard your vital organs and have fractures on your wrist, which she had none of those things. Her injuries in themselves were their own irrefutable evidence that she was unconscious during this crash. So let's dive into the hard proof of her innocence. The first and most obvious contradiction by the prosecutor: her injuries alone were consistent with someone being unconscious and limp during a crash. She had shattered ribs, a broken femur, and a torn liver. This proves she did absolutely nothing to brace herself or protect her own body before impact. When a conscious driver intentionally crashes a car, even in the case of a murder-suicide, as supported in the literature listed above, they almost always try to protect their vital organs at the last millisecond, leading to specific defense fractures in the wrist, arms, or ankles. The fact that her torso took the full unbraced brunt of the steering wheel column to break her ribs and lacerate her liver further supports the defense's medical narrative. Her body was completely limp before the car ever hit the wall. But the most significant factor of all in Mackenzie Shirilla's innocence was her POTS diagnosis in 2017. The post-trial defense hired world-renowned POTS expert Dr. Kamal Chemali to review the case. He submitted a sworn affidavit to the court after reviewing Mackenzie's case. Dr. Chemali explicitly cited, quote, abnormally low blood oxygen and elevated lactate levels, end quote, in her post-crash emergency room data. He stated that the combination of the low oxygen, the elevated lactate, and her complete amnesia following the crash are, quote, classic markers of a seizure or similar autonomic event, end quote. The EDR data blackout connection. Dr. Chemali concluded that her clinical markers were, quote, consistent with loss of consciousness, end quote, at the time of her fatal collision. To prove this, he cited a 2018 peer-reviewed study on seizure-related car crashes listed above, noting that the EDR data, traveling perfectly straight into a building with the throttle pinned and zero braking, is the exact characteristic trajectory of a driver who suffers sudden unconsciousness behind the wheel. Unfortunately, the judge ultimately decided not to accept the appeal due to it being submitted one day late, due to the defense attorney's failure to calculate for leap year. The judge absolutely had the power to accept the appeal, but chose to refuse it anyway, and this sealed Mackenzie's fate. The only thing that could potentially save her now would be a very unlikely pardon from the governor of Ohio. Even though the judge ultimately refused the appeal, shortly after the defense filed their appeal, the prosecution still launched a counterattack, attempting to discredit Dr. Chemali and the new hard evidence, proving Mackenzie's innocence. It seems absurd, but this is a very common practice, and the way these prosecutors acted is actually really common in the American judicial system. So why did Mackenzie really lose at trial? So first, it's dangerous to be chronically ill in America. Much like what young women face in the American medical industry with gaslighting and systemic bias, they also face that bias within the American justice system. So most people don't know this, but medical diagnoses paperwork, like your visit summaries, your diagnoses paperwork, is considered hearsay in court unless you actually have a expert medical testimony, like an expert medical witness. In order for your diagnosis paperwork to be accepted, you must hire a medical expert to come testify in person at your trial on the witness stand to review the diagnosis paperwork in front of the entire courtroom real time. Then your attorney needs to be good enough to ask the right questions and use the correct procedure to have that medical paperwork submitted into evidence so that it could actually be reviewed by the jury or by the judge. Hiring a medical expert to testify can cost minimum $10,000, and it can even be difficult or impossible to find one, even if you can't afford that. Alternatively, you can have your primary care physician come, but there's a paradox with that. It's a lose-lose for the chronically ill patient, because even if you're lucky enough and your PCP is kind enough to come testify for you, they will be publicly dragged by the prosecution no matter what. That's the standard operating procedure for the prosecution. They always attack the provider's reputation. They scrutinize or criticize their entire career, and they'll always say, "You're not an internationally known expert. Why should we believe anything you say?" Or, "You're just a family medicine doctor." Providers are extremely risk averse in the first place. We know this, especially chronically ill patients. It's almost impossible to get care because of this. And since the providers are guaranteed to be dragged publicly on the record, public record, and that they'll have their reputation attacked, this is something providers are very aware of. And this is something that expert medical testimony experts know about. And that's why they charge such a premium. That on top of the fact they also have to travel, and a lot of times they're sacrificing many patients that they could be seeing in that time as well. So if you are actually privileged enough and lucky enough to be able to find a medical expert to come testify in person at your trial, it's still a lose-lose for the patient, because the prosecution always says this: you didn't know the patient personally, you weren't their primary care provider, so how could you know enough about the specific patient for anything you to say to actually matter? And the classic, were you at the scene of the crime? Were you there with the first responders at the hospital? How could you know more than the people who are actually there? This is the sad truth of what a chronically ill patient faces if they are unfortunate enough to end up in a situation like Mackenzie Shirilla that was 100% not your fault, where you had an autonomic seizure or were unconscious and were in a car accident. Next, we're going to cover what really happened with Mackenzie's defense. How did her lawyers drop the ball not once, but 2 times? Why did the state pick the case up in the first place? Like, how does it end up being the state of Ohio versus Mackenzie Shirilla? What is that process? And like, how did that come to be at all? And what can you do to prevent this from happening to you? Or at least what measures can you take to protect yourself as a chronically ill patient if, God forbid, you ever end up in a situation like this? If you want to continue to support the work we do here at Visible Illness, subscribe to our YouTube channel and donate to our GoFundMe. Clover needs life-saving surgery, and we need to see a lot of EDS experts right now, and they're all cash only. Anything you can donate helps. We're super grateful. So another reason the defense really lost this trial is because of the prosecution's strategy. The patriarchy is very powerful, and using the crazy girlfriend trope is highly effective. They really relied on Mackenzie's digital footprint, her relationship drama, and threatening texts to paint her as a calculated, malicious actor. They used the whole toxic relationship angle to launch a narrative warfare, and it was highly effective. There is a patriarchal expectation from how women should grieve and how much remorse they should show and for how long for their loved ones. And the prosecution really leaned into this, right? So let's look at the technical aspect of how her defense really let her down. So Mackenzie Shirilla was represented by James McDonald. He is a veteran Cleveland area criminal defense attorney. So McDonald is an experienced, established lawyer in the Cleveland area, and this case was in Cuyahoga County. But his handling of this case really does show something that's really scary for chronically ill patients, and that's that standard criminal defense attorneys are really not equipped to deal with a complex chronic illness case. We're going to look at some of the actual quotes from the trial, and I think you will be appalled at what an absolute disaster this defense attorney was for Mackenzie Shirilla's case and how bad he really let her down. So one of the first huge fatal decisions was the waiving the jury trial. They chose a bench trial. That's where the judge makes the ruling, not a random selection of 12 people from the county that we're in. And they probably did this because 12 regular citizens from Cuyahoga County would likely find this whole not remorseful teenage girl painted as a crazy girlfriend trope. It's likely the Cuyahoga County citizens that would have been selected for the trial jury would have really been affected deeply by these two young boys who were popular being killed, especially one of them was like a running back for the county, for the school football team. So I'm sure the defense attorney probably advised the family to go with the bench trial, just banking that the judge would be more logical than a jury. Unfortunately, Judge Nancy Margaret Russo proved to be much harsher than any jury likely would have been. So the single greatest failure of this defense was that there was no expert testimony. So rule number one, handling any case where there's a medical diagnosis, you must secure a expert medical testimony, full stop. Mackenzie has POTS, but a defense attorney must hire a forensic specialist or neurologist or cardiologist who specializes in POTS to come testify under oath and explain the condition to the judge themselves. It's likely that the defense probably couldn't find a medical expert that was willing to come testify, or the family didn't have the funds. So the lawyer, McDonald, he did not put a single medical expert on the stand. Instead, he relied almost entirely on Mackenzie's mother to read from her daughter's 2017 chart history and medical diagnosis paperwork. Naturally, a mother's testimony is viewed as inherently biased, desperate, and medically unqualified in a courtroom. By failing to secure a doctor to testify about her post-crash blood oxygen drop and how an autonomic blackout locks a foot on a gas pedal, the defense completely let Mackenzie down and really was like instrumental in leading to her prosecution. So why didn't the defense focus on the POTS diagnosis fully? The golden rule of mounting a sudden medical emergency defense is that you must have a single unified narrative. You must prove exactly why the body failed. Instead of locking into the POTS narrative, McDonald threw multiple contradicting theories at the judge to see what would stick. His closing arguments, this is brutal. This is hard to listen to, so buckle in. Quote, is it just kids being kids? Is it Dominic grabbing the steering wheel? Is it Mackenzie maybe speeding and she goes like that to avoid an accident? Is it sudden acceleration panic? Those are all possibilities, end quote. That is what her defense lawyer said during his closing argument. It's just embarrassing and tragic. So her defense lawyer, McDonald, completely diluted the medical defense by saying these things. And he basically told the judge, we don't know what happened, which totally gave the judge permission to dismiss the POTS theory entirely. The final and most devastating blow in this case was they lost the appeal. So after they lost the original trial, the defense hired a new legal team, obviously. They hired this really badass law firm called Friedman, Nemec, Long, and Grant, LLC. They realized the massive mistake their original defense lawyer made. And first thing they went out and did was hire the world-renowned POTS expert, Dr. Chemali. After reviewing Mackenzie Shirilla's unredacted hospital data, explicitly stated in a sworn affidavit that her clinical markers were completely, quote, consistent with sudden loss of consciousness, end quote. So finally, the defense had irrefutable evidence that Mackenzie was unconscious. So the new defense team filed called a petition for post-conviction relief, or a PCR. This is like, when I say appeal, like I'm talking about this PCR. It's what you file when the original lawyer let you down and your rights were violated because you weren't provided with a fair defense. Because her original lawyer failed so badly, this new law firm was able to file this legitimately. They argued that the original defense lawyer, McDonald, failed on three specific fronts. He failed to retain or present a specialized medical expert. He failed to properly admit her historical medical records documenting her POTS diagnosis. And he failed to introduce a specific batch of text messages that contradicted the state's intent timelines. We all seen the documentary. The one big part of the prosecutor's argument was that Mackenzie earlier, before the crash, had threatened to crash the car and said, I'm going to crash or something like that. So the prosecution really relied heavily on this, but it turns out they were picking and choosing what parts of her text messages match their narrative. This new PCR they were filing and this new text messages the defense submitted, turns out her boyfriend had actually started these arguments and he had been texting and apologizing later that same day for starting the argument, for causing her to swerve the steering wheel. And the whole conversation, the whole picture completely discredited this whole narrative that Mackenzie was threatening to crash the car or was driving erratically. because of those three things, like they had a legally sound case to basically appeal the original judge's decision. So when you file this post-conviction relief, the first thing that happens, like soon as you file something as the defense, the prosecution always files a counterattack. So what the prosecution filed right away was called a brief in opposition. And that's where they actually attacked Dr. Kamal Chemali's affidavit. They said that Dr. Chemali was a late stage addition who lacked personal firsthand clinical knowledge of Mackenzie Shirilla because he was not her treating physician and because he did not personally examine her at the scene of the crash. The prosecutors argued that the abnormally low blood oxygen and spiked blood lactate as biological footprints of a seizure were simply the natural biological result of surviving a 100-mile-per-hour impact and being crushed inside a vehicle. Now, the prosecutors provided no medical literature to back this up. It was literally hearsay. But I just want to keep in mind, it's really important to understand the defense is offering irrefutable evidence backed by medical literature, peer-reviewed medical literature to state these things. And the prosecutor's argument against it was literally just saying things without backing it up with any medical evidence. Lastly, to explain why Shirilla's foot remained pinned to the floor at 100% capacity without a single brake attempt, Dr. Chemali cited foundational neuro studies proving this is exactly how an unconscious body behaves behind the wheel. The prosecution simply dismissed that entire scientific framework as speculative. So the prosecution, this is so infuriating, called peer-reviewed medical literature, quote, speculative, end quote. So it's absurd. But ultimately, this brief in opposition didn't even matter because the court refused to accept the petition for post-conviction relief due to a minor technicality on a filing date. So they filed one day late. This new super tough defense team that her mom hired, they literally missed the deadline by one day. And because of that, the judge would not accept the appeal. So under Ohio Revised Code, a petition for post-conviction relief must be filed within precisely 65 days of a trial transcript being docketed. So the original transcripts were docketed October 24th, 2023. The appeal was filed October 24th, 2024. Exactly 1 year, right? But leap year. So because 2024 was a leap year, the prosecutors argued that this was a late filing because the actual Ohio state code says 365 days. It doesn't say 1 year. It says 365 days. And because of that, this new defense team missed the filing date by 1 day. Because of this late filing mistake by the defense team, this essentially finalized Mackenzie's life sentence. Without a pardon from the Ohio governor, this was really the end of the road and they can't appeal anymore because you only have one shot at filing a post-conviction relief. So why would a law firm wait until the last possible second to file one of these appeals? You have this luxury law firm, they're paid over $100,000 to do this thing. They have a whole year to work on it. Why would they wait to hit the submit button until 11:59 p.m. at the last second? So here's what happened. In post-conviction law, you get one shot at filing this post-conviction relief. So if you file the PCR in month 6, but then new evidence comes out in month 8, you can't update it, no matter what new evidence you find. So what happens is lawyers wait to file until the last possible second, or essentially postpone working on it until the last possible second, just in case new evidence pops up. There's also the factor of they're dealing with the American medical system, and I'm sure going back and forth with all of the hospitals and dealing with Dr. Kamal Chemali and getting this sworn affidavit all took lots and lots of time, surely. And essentially, high-end law firms juggle a lot of big cases. And because Mackenzie Shirilla's case had a 365 days away, they likely pushed it on the back burner until the last possible minute. It's no secret that these PCRs are thrown together at the last 72 hours right before the filing date. And what probably happened was that when the 1 year deadline was set, so on October 24th, 2023, a paralegal in the office probably put a 1 year reminder on exactly 1 year later. But because the law says 365 days and not 1 year, and it was a leap year, no one actually counted the actual days. They just trusted their automatic legal system and the paralegals. And that literally led to this appeal not being submitted and the judge refused it. Again, Super tragic. The judge absolutely could have accepted this appeal, but refused to. So what happens for a state to pick up the case? Like, how did it come to be the state of Ohio versus the Mackenzie Shirilla? So when a driver is involved in a high-speed crash that results in a death, the local police, in this case, the Strongville Police Department, have a county coroner that conducts a mandatory vehicular homicide investigation. People in these positions of power, and one great example of this is fire marshals. The data has showed time and time again that these people in these positions of power lead to a lot of wrongful convictions. A lot of these families that get convicted of intentionally burning their houses down, you find out it was just the fire marshals being a hammer looking for nails come in and they get suspicious of like faulty wiring, and these families get wrongfully convicted. It happens all the time. It's no different here with these investigators with these crashes. So once detectives pulled the black box, the EDR, from the car, and they saw that the 100-mile-per-hour pinned throttle, they handed all of their files and data over to the Cuyahoga County Prosecutor's Office. So that is the state government agency that's responsible for prosecuting crimes on behalf of the public. So a grand jury officially indicted Shirilla, and that's when it became the state of Ohio. Formerly, it became the plaintiff, and it was state of Ohio versus Mackenzie Shirilla. So normally when a teenager causes a fatal car accident, the state charges them with aggravated vehicular homicide or involuntary manslaughter. It was a little unusual in this case to go for full-on 4 counts of felony murder. The state just looked at the EDR data and, again, hammer looking for nails. And because of this massive power imbalance, you have the state picking up a case like this. They have government salary cash to hire reconstruction and experts, to have digital forensic investigators going through all of Mackenzie's like social media and their phones and everything. And they have a team of multiple seasoned prosecutors working full time to secure a conviction on this case. They're just focused on winning. They're not focused on the facts. They're not focused on the truth. The way the system works is that these people are just trying to win at any and all costs, basically. And in theory, it works if you have an equally good defense. The truth comes out. But unfortunately, when you have a Midwest small family like this, have the funds to have an equally good funded defense. And in that power imbalance, you often see a lot of wrongful convictions as the result of that. So what can you do as a POTS patient to protect yourself now? Is there anything you can do now to help at least increase your odds of surviving a nasty situation like this? So the first thing, and probably the most important, is to understand the more medical documentation you have for your condition, the better. And the better published your providers are that are diagnosing you, the better. So there is very much a hierarchy in the medical industry. So your local doctor is usually not going to have much power versus like a world-renowned POTS expert. So if you go to a local cardiologist that diagnoses you with POTS, that's not going to have nearly the weight as world-renowned POTS expert that is published in all of the peer-reviewed literature. So if you can get a POTS diagnosis from this renowned expert that's published, and then go get a POTS diagnosis from a different renowned expert who's also published, that's ideal. At that point, you're more likely to have access to better care at that point. And you also have another layer of protection as should you ever end up in a tragic situation like what happened with Mackenzie Shirilla. And one of the most powerful weapons in the fight for defending yourself as a POTS patient is something called infrared dynamic pupillometry. And this was actually pioneered by Dr. Chemali himself. So he found a way to take some technology that already existed and do this test on your pupils to identify if someone has POTS, but actually does it with irrefutable hard biological data. So if you can go get this infrared dynamic pupillometry test done, that is like irrefutable hard scientific evidence that you have POTS. So the way it works is your pupils are governed by the autonomic nervous system. So you can't actually consciously force your eyes to dilate or constrict. So since it's involuntary, that's like why you can't fake it. And that's why the test is like powerful and proving you have POTS. They have you sit in a dimmed room facing a specialized scanner, and the machine fires a millisecond long flash of light into your eye while a high definition infrared tracking camera records your pupils' reactions at 250 frames per second. And they check for constriction velocity, latency, redilation velocity, and other things. So in this test, it detects autonomic latency or pupillary instability. Because it relies on all of this infrared pixel tracking and data, It cannot be faked, exaggerated, or dismissed by a skeptical doctor or cynical courtroom as anxiety, which is incredibly powerful because that's something patients face in a big way. Unfortunately, this is not a standard machine. There's not a lot of them. They're located specifically in tier 1 autonomic centers of excellence. And here's a few places where you can get them done. I'll just breeze over this, but you can view this whole Substack post using that link in the top left corner there. That QR code will take you to the Substack post. Cleveland, the Mayo Clinic in Rochester, Minnesota, Boston, New York, Philadelphia, San Diego, San Francisco, Nashville, and Dallas. Ironically, there isn't anywhere to get it done in Los Angeles, but in general, Los Angeles is usually arguably the best city in the country to have access to care as like a triad patient, EDS patient, POTS patient, etc. However, if you are in LA, you're going to have to travel to San Francisco or San Diego. Reality check with this waiting time is like, you're probably looking at 6 months to 2 years. If I had to guess, I would say 6 months in San Francisco, but 2 years in Nashville, because there's like less machines available. Even if you can find a center, it's not so easy to get in. You need to have a specialized referral from either like a cardiologist, a neurologist, an EDS expert, etc. And usually with these places, in my experience as a medical advocate, what I usually do is call the place first, figure out all of the info they need for referrals. So a lot of times they might have a special referral form. They might want you to list specific CPT codes when your provider is sending that referral. A lot of times they'll want to review the patient's medical records first to decide if they even want to take the patient at all in the first place. So because they have to basically triage and decide, we can't see everyone. So a lot of times when I'm helping patients get care, I'll help them fax over all of their medical records to the place first before the provider even sends the referral in the first place. And that'll really help move things along and get you in these places a lot faster than if you just hope your provider does it when you ask them and they actually don't. Getting these medical diagnoses and hard data on your condition can be brutal and take many years. But if you are committed and you're resilient, it can protect you. And God forbid you ever end up in the situation like this innocent young girl from the Midwest who had an autonomic seizure. Thank you guys so much for your support. So much love. Make sure to subscribe for more. We have so many great videos coming up. You don't want to miss out. Here's the link for our link tree. Make sure to subscribe to our YouTube. Any donations go a really long ways. We thank you guys so much for those with all of our love from me and Clover. If you're someone who's chronically ill, we see you, we believe in you.